Welcome to Building Your Legacy, Southern Arizona Estate Planning with Allison Manning.
Hello, everyone. Welcome to Building Your Legacy in Southern Arizona with attorney Allison Manning. Allison is an estate planning attorney who helps individuals and families across Southern Arizona create clear, practical plans for the future. She works closely with clients on wills, trusts, powers of attorney, and long-term care planning with a focus on making sure those plans actually work when they're needed. I'm Sean O'Connor, and today Allison and I are talking about when an estate plan should be reviewed, what life events may require updates, and how to make sure your documents still reflect your wishes. Good morning, Allison.
Good morning, Sean. Thanks for having me.
You bet. You bet. The old estate plan updating, I always thought, I don't know. I'm working from this space of like, okay, major life events, but how often should it be reviewed? Is there like a industry best practice?
I believe you should update your estate plan and review your estate plan every 2 to 3 years. It's important to look at your assets that are titled in the name of the trust and review those at least annually. But with an estate planning attorney, you should come in, visit with me about every 2 to 3 years.
Got it. And I already mentioned life events. What are some of the sort of triggers for people to be like, oh, this is another reason to call Allison for an estate plan update?
Right. Well, I like to tell my clients to come in every couple of years so I can review with you law changes and confirm that your agents are right. But there are life events that I'm not going to be aware of without my clients notifying me. Some of those life events are getting married, having a child, getting divorced, moving, retiring, having a loss in the family, someone has passed away, or an illness, a diagnosis. Those are things that are important for you to reach out to me and let me know, hey, these things are happening in my life, and do they affect my plan, or how do they affect my plan?
Yeah, I was going to say I guess it depends on the plan or your goals. Does a marriage or divorce always affect an estate plan?
Absolutely. It affects your estate plan. It, changes your life. It may change some of your planning goals, or it may not. But by getting married, there's actually some rights that under the law your new spouse has. There's oftentimes when you get married where you don't want your plan to be changed, you still want it to go to the beneficiaries you previously designated. For example, in a second marriage, maybe your assets you both agree are still going to your children, but you haven't acknowledged this in your estate plan. So it's very important that you do so. There are certain assets, retirement assets, that spouses are automatically given rights that need to be changed or designated. Additionally, in a divorce, many times in a divorce, one of the spouses will agree to leave a life insurance policy to the ex-spouse to take care of their children, but they don't redesignate that ex-spouse as the beneficiary. And under some laws, that could cause them to not be the beneficiary anymore because the divorce would terminate their rights. So there's many times when those events affect your plan that you may not even realize.
Yeah, does what you sort of delineate in an estate plan, and say in a trust, does that trump the state, sort of the default state laws? That's what you're saying, right? Where like in the case of the second marriage, if that were my wife, like there's a certain automatic assumption that certain things would go to her, unless in the trust it's like, no, these go to my kids.
Right. So there's certain assets, like I was explaining, the retirement assets can automatically go to your wife if there's not actions to designate those to the kids and the spouse signing a spousal waiver. Those don't typically pass through your trust necessarily, but there are some state laws that provide certain protections to spouses so that they aren't left with nothing. And so we want to make sure that if your intention is to leave something to the spouse, that you do so, but also that if your intention is to exclude the spouse, which many, like I was explaining, many second marriages, you may agree, you each provide your own wealth in the marriage. You don't need to provide for each other. then oftentimes the state law can insist that those spouses get some assets that they weren't meaning to leave to them. Arizona is a community property state, so there's some assets that we need to make sure are properly titled and that we are opting out of community property if that's not the option that we want. Otherwise, there's some rights that attach to that surviving spouse.
Got it. Yeah. So a lot of things to consider and designate, so to speak, so that you don't get so the state's not making decisions on your behalf. Um, what about financial changes? Are there certain financial changes that should prompt someone to revisit their plan?
Of course, there's times in your life where you may receive an inheritance that changes the dollar amount of what your estate looks like. We always want to make sure that we're staying, we do some proper planning or stay under the exemption amount so that we're not having to pay the federal tax just because your estate is over the 15 million with inflation. So we want to watch for that. There's additional times where it may change who gets what based on the size of the estate that you have. Times of retirement, that may change how you want to leave things. I've had clients who've left specific dollar gifts to certain beneficiaries, and then they have a residual amount going to their family members. Well, that their estate was so small that those dollar amounts took over the whole estate and ended up leaving their family really nothing or very little. And had they taken time to review their plan, they would have changed that, because when their plan was drafted, they had considerable more assets than what they had when they passed away. So, of course, whether you get an influx of money or a decrease in money, possibly you've paid a lot of money towards caregivers or nursing homes at the end of your life, which might change the focus of where you really want to leave your money.
What about I don't know if I'm not sure I'm using the right term, a trustee or the designated person, right? There's someone whose job it's going to be to kind of uh, carry out your wishes. There's responsibilities they have. What if that person is not the right fit anymore, or the relationship changed, and you're like, and I don't want Allison to do this thing for me, or maybe that person is like, hey, Sean, I don't want to do that.
That's a great point, and it does happen as life changes, as time goes on from when you initially create your plan. The position of your successor, trustee, agents under your power of attorney, your personal representative under your will, that role may change for you and who you want to be in that role. They may no longer have the time to do that. They may have proven to not be responsible with money. Possibly they moved far away, or their job just really takes them away from being the right person. And thankfully, under most trust, you have the ability to make that change as long as you're able to. So it's important that we review that. That's one of the terms that we want to review every couple years. And if one of them passed away, again, that's something where you're going to reach out to me and say, hey, my agent has passed. Who's my successor agent after them? Do I need to change that and designate somebody new in this role?
So you have your main agent, and you also slot in a backup. That's typical.
I recommend that you have at least 2 backups to yourself. So hopefully during your lifetime, you're managing your own money. You're not needing somebody to do that for you. Then when you pass away, you should have a backup named. I do like my clients to name 2 if possible. Sometimes they name 3 or 4. They just make a whole list of them. But there
The whole
are
team.
occasions where people only name 1 because they really don't know anyone else to be in that role.
Yeah. And it can be anyone.
It could be anyone to be in that capacity. I always say make sure, one, it's a right fit, that they understand the responsibility and the time commitment in stepping in, that they are fiscally responsible so that you don't have concerns with them managing the money. And location used to be a really big deal if they were close by, but in our world today, we are
Less
able
so,
to
huh?
have a lot of people that can cross country and do things remotely. So it's not necessarily about location, but if there's a tie between two possible choices, then I always say go with the one who is closer by or able to get to you easier if they need to.
Yeah.
I always suggest start with friends and family first, And because they usually will do it for a lower fee, possibly, or maybe because they're the beneficiaries under your estate plan and they know you better. But if not, you can look to a paid fiduciary, an attorney, a CPA, or someone else in that capacity.
Got it. Okay, so someone's out there right now, they've got a plan, uh, but they haven't reviewed it in many years. I mean, the obvious what they should call you. But like, is there something specific they should be doing if it's been sort of sitting on the shelf for a number of years?
Absolutely. Take it off the shelf, dust it off. If it's my clients, I'd say come on in, bring those documents with you. It's good to open it up and take a look. A lot of people don't know what the documents even mean, but the things they're going to look for is who are their successor trustees? So who steps in if they're unable to act? Who are their beneficiaries and what is that percentage? For married couples, you're going to want to look at terms as to whether or not the trust becomes irrevocable or part of it becomes irrevocable at the death of the first spouse. What work has to be done for that surviving spouse? And for many people, that's just too much for them to want to do on their own or make sure they're doing correctly. So definitely bring those documents in, take a look at them, so that way we can confirm the terms are what you think they are in your estate plan and that your plan will go as you hope it will when you're deceased or incapacitated.
Good stuff. And now, the inevitable sort of flip side of that, in my mind, it's like, okay, so the outdated estate plan, right? They didn't come in. Oops, it's outdated. I die. What happens? Like my loved ones, like what are the scenarios there that I'm trying to avoid?
So oftentimes having the wrong person in that role and not acknowledging maybe some family dynamics. Now we have maybe someone in that successor trustee position who shouldn't be doing that, who doesn't get along with some of the beneficiaries or doesn't have your best interest. Sometimes we might need to do a process called decanting, which is where we change some terms in an irrevocable trust. But if your trust is so old, it may not allow us to do that without some court participation in it. Additionally, there can be some beneficiaries who are on government assistance who now have lost their government benefits because they received an inheritance. So there can be a lot of problems that show up for your beneficiaries that you did not intend. And many of them can end up landing us in the court system in order to either litigate, negotiate, or change terms. And that your whole plan was designed to avoid the
I
court
was going to
system.
say, right.
So
But the irony there is that the plan itself is designed to try and keep you out of court or minimize that rigmarole.
absolutely. And so just going in, spending 30 minutes every couple years, checking in with your attorney, making sure your plan still works. One, it defends the integrity of your plan because we know your plan's going to work. Plus, if anyone was to ever challenge your plan, we can show you've come in several times and said, this is what my plan is. And it's been that way for years. And so it helps support the plan design ultimately and reduce the ability for any type of challenges to be successful.
Oh, that's good. That's good. Good to know. Yeah, I'm imagining to me, it conjures, bad TV movie, but, the angry child, dad didn't want that. And then, it's like, well, actually, he just updated his estate plan 18 months ago. Like, that's kind of the scenario that protects against. One thing.
Yeah,
Sure.
absolutely. And it shows the continuity of what the plan design was and that
Mm,
they had capacity. They were not under undue influence and they understood what the results were of them designing the plan the way they did.
yeah. Dad's hated you for years. It's not a new thing. No,
Right. You've been the troublemaker always, and this is this
right.
is what happens.
Oh my God. Allison, we're just about out of time here, but thank you so much for your expertise and point of view. Always a pleasure talking to you, and I sure will talk again soon.
Thanks so much, Sean.
That's it for today's episode of Building Your Legacy in Southern Arizona with Allison Manning. To learn more or get specific guidance on your situation, you can visit Allison's website, AllisonManningLaw.com. Thanks for listening, and as always, maybe leave us a thumbs up, subscribe, share a link with someone in your world who maybe is working on an estate plan. That can be super helpful. I'm Sean O'Connor. Have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.